We just got a ruling that gun owners have been waiting on for almost a century, and it might completely reshape the fight over suppressors and the NFA going forward. A unanimous 3-judge panel on the Fifth Circuit Court of Appeals handed down a decision that officially recognizes suppressors as protected arms under the Second Amendment. That part is a real win. It is unanimous, and it is the first time a federal circuit court has ever said it this plainly. But before you get too excited, there is a massive, frustrating catch buried inside this ruling. Because even with all 3 judges agreeing that suppressors are constitutionally protected, the conviction in this case still stood. The defendant won the constitutional argument and still lost his freedom, and the reason why ties directly back to a previous ruling that trapped this panel and forced their hand before they ever got to decide the case on its own terms. So in this video, we're going to break down exactly what this new case says, how a prior precedent boxed in 3 judges who clearly did not want to be boxed in, why this creates a direct circuit split with another federal court that ruled the complete opposite way 2 weeks earlier, and why the Supreme Court may finally be forced to step in and settle this once and for all. If you want to keep up with this story as it develops, now is the time to hit subscribe and turn on notifications, because rulings like this one are dropping fast right now, and there is more coming on this exact issue within the next few months. Your engagement is genuinely what keeps this kind of coverage in front of people who need to see it, so thank you for being here. To understand why this new ruling is such a big deal, and also why it still resulted in a loss for the defendant, you have to go back and look at the case that set the trap in the first place. That case is United States versus Peterson, and it has been looming over every suppressor case in the Fifth Circuit ever since it was decided. Peterson involved a man charged under the National Firearms Act for possessing an unregistered suppressor. He challenged the law using the Supreme Court's Bruin framework, arguing that the government could not tax and register something that is a constitutionally protected arm without running into serious Second Amendment problems. To really appreciate how deep this fight goes, remember that suppressors have been federally regulated since 1934, back when the National Firearms Act was originally passed. Congress lumped suppressors in with machine guns and short-barreled shotguns, treating them as if they were inherently dangerous devices that needed a tax stamp and a lengthy background check just to legally own one. For decades, nobody seriously challenged that framework using the Second Amendment argument, mostly because the Supreme Court had not given lower courts a clear test for what counts as a protected arm. That changed with Heller in 2008 and then again with Bruin in 2022, when the court said judges have to look at the plain text of the amendment first, then at history and tradition, rather than weighing government interests against individual rights, the way courts used to. Once Bruin came down, gun rights litigators across the country started bringing suppressor challenges specifically because the text of the Second Amendment protects arms, and a strong argument exists that a suppressor is either part of the arm itself or, at minimum, an accessory that facilitates the use of a protected arm. Peterson was one of the first major test cases to work its way through a circuit court under this new framework. Here is where it gets interesting. During that litigation, the Department of Justice actually reversed its own position, which almost never happens. Under the prior administration, the DOJ had argued that suppressors get no Second Amendment protection at all. After the administration changed, the DOJ shifted and conceded that suppressors enjoy at least some level of constitutional protection because they help people exercise their right to keep and bear arms effectively. That is a massive concession from the government. You would think that alone would be enough to win the case. But the Fifth Circuit panel in Peterson still ruled against him. Their reasoning was that even though suppressors might be protected, the NFA's registration and tax scheme functions like what is called a shall-issue licensing system. Under that theory, as long as there is an objective process where a citizen can apply, pass a background check, and eventually get approved, the restriction survives constitutional scrutiny because it is treated as an administrative hurdle rather than an outright ban. The panel essentially assumed, without deciding, that suppressors are protected arms, and then said the tax and registration requirement does not meaningfully burden that right. Peterson lost, and that ruling became binding precedent across the entire Fifth Circuit, which covers Texas, Louisiana, and Mississippi. That is the trap. Once a 3-judge panel sets a rule like that, every future panel in the same circuit is bound by it under a doctrine called the rule of orderliness. A new panel cannot simply ignore a prior panel's holding, even if all 3 judges personally disagree with it. Only the full court sitting en banc or the Supreme Court can actually undo it. So Peterson sat there as a loaded trap waiting for the next suppressor case to walk into it. It is worth pausing on how strange this outcome really is, because most people assume that if the government itself admits your constitutional right is at stake, you win. That is not how the rule of orderliness works. It does not matter that the DOJ flipped its position. It does not matter that the underlying constitutional question was conceded. What matters is that a prior panel already wrote a rule down, and that rule becomes the floor every future panel has to stand on until someone with the authority to remove it does so. That is the exact mechanism that trapped the next defendant before his case ever reached the judges who would decide it, and it is worth understanding clearly, because it is going to keep trapping the next person, and the one after that, until either the full Fifth Circuit or the Supreme Court steps in. There is also a practical side to this that a lot of coverage glosses over. Roughly 8 states currently restrict or outright ban civilian ownership of suppressors at the state level, entirely separate from anything happening in these federal circuit courts. Even if the Fifth Circuit fully overturned Peterson tomorrow, and even if the Supreme Court eventually agreed that suppressors are protected arms nationwide, state-level bans in places like California and New York would still need to be challenged separately in their own courts. This fight is not a single light switch that flips everything at once. It is a slow, layered process, circuit by circuit and statute by statute, and this new ruling is one more piece of that much larger puzzle. And that next case walked in fast. It is called United States versus Como, and it was decided by the Fifth Circuit on June 18th. Brennan Como was prosecuted for possessing unregistered suppressors that he admitted making himself using solvent trap kits, the same type of parts kit that keeps showing up in these prosecutions again and again. He never registered them under the NFA, he never filed the required paperwork, and after local law enforcement referred the case to the ATF, he was convicted and sentenced to 2 years in prison. When the case reached the appellate level, he argued the exact same constitutional theory that Peterson had argued. This time, writing for a unanimous panel, Judge Jerry Smith went further than any Fifth Circuit panel had gone before. He did not hedge. He did not assume without deciding. The court explicitly held that suppressors fall within the plain text definition of arms under the Second Amendment. The panel walked through the practical function of a suppressor, pointing to reduced hearing damage, reduced recoil, elimination of muzzle blast, increased accuracy, and faster follow-up shots, and said all of those functions make a firearm safer and more effective for lawful self-defense. Under the Bruin framework, an accessory does not need to be strictly necessary for a firearm to operate. It only needs to facilitate the constitutionally protected activity of armed self-defense. Based on that reasoning, the court held in the majority opinion itself that suppressors are arms, full stop. That is a genuinely massive constitutional holding. For the first time, a federal circuit court flatly stated that suppressors are protected arms under the Second Amendment. If this had been a case of first impression with no binding precedent standing in the way, Como almost certainly wins outright, and the entire suppressor registration scheme would be sitting on very shaky ground right now. But here is the catch. Because Peterson already existed as binding circuit precedent, the panel in Como was legally required to apply that shall issue reasoning regardless of how they personally felt about it. And Como, in his specific case, had not put forward evidence showing that the NFA's registration process had actually been abused against him through something like exorbitant fees or unreasonably long processing delays. That meant he could not clear the bar that Peterson had set. So even though the court agreed suppressors are protected arms, it still upheld his conviction, because under Peterson, the registration and tax scheme survives unless a defendant can show the process itself is being weaponized against him specifically. Como had not made that argument, so his challenge failed at that step. Win the constitutional argument, lose the case. That is exactly the kind of frustrating outcome that keeps happening in this circuit right now, and it is going to keep happening until Peterson itself gets knocked down. Now here is where this story takes a turn that a lot of people are going to be talking about. This was not just a quiet, reluctant application of bad precedent. 2 members of the panel used this opinion to send a direct signal to the rest of the Fifth Circuit that Peterson needs to be revisited and overturned. Judge Edith Brown Clement, joined by Judge Stuart Kyle Duncan, wrote separately to say that Peterson took a narrow, almost throwaway line from the Supreme Court's Bruin decision about shall issue licensing for concealed carry permits and stretched it into a shield for an entirely different federal registration and taxation scheme. The concern being raised is that Peterson quietly resurrected a form of interest balancing, weighing the government's interest against the individual's right, which is precisely the approach the Supreme Court rejected in Bruin. Bruin was supposed to end that kind of judicial balancing test. Critics of Peterson argue it snuck a version of it back in through the side door by rebranding a tax and registry scheme as a mere license application. So what you have right now is a 3-judge panel that felt legally trapped, followed the rule that bound them, but used the opinion itself as a vehicle to all but beg the full Fifth Circuit to take this issue up again and kill Peterson once and for all. That is an unusual and honestly a pretty aggressive move for sitting federal judges to make. It tells you these judges do not think Peterson should be the law of the circuit much longer, and it hands Comeau's legal team a roadmap for exactly how to ask for en banc rehearing. And this is where the story gets bigger than just Louisiana, Texas, and Mississippi. Just 2 weeks before Comeau came down, the Ninth Circuit out on the West Coast ruled on the exact same underlying question in a case called United States versus de Bourbe, and reached the opposite conclusion. That panel held that suppressors are firearm accessories, not arms in their own right, and therefore fall outside the plain text protection of the Second Amendment entirely. So within roughly 2 weeks of each other, you had one federal circuit saying suppressors are constitutionally protected arms, and another federal circuit saying they are not protected at all. That is about as clean a circuit split as you can get. When two circuits explicitly disagree on the same legal question within weeks of each other, that is exactly the kind of conflict the Supreme Court exists to resolve. Legal analysts tracking this are already pointing out that this split practically hands the Supreme Court a reason to finally take up the suppressor question directly, something gun owners have been asking the courts to settle for close to 90 years, going all the way back to when the NFA was first passed. Whether that vehicle ends up being Comeau, de Bourbe, a fresh petition out of the Peterson litigation itself, or some other case entirely, the pressure on the court to grant review is mounting fast. It also matters how the Ninth Circuit got to its answer, because it shows you the two competing theories that are about to collide in front of the Supreme Court if review is granted. The Fifth Circuit's approach in Comeau treats the suppressor as functionally part of the arm itself, reasoning that a firearm equipped for safe, accurate, hearing-protected use is more capable of serving the core lawful purpose of self-defense than one without it. The Ninth Circuit's approach in de Bourbe instead treats the suppressor as a separate accessory, similar to a scope or a sling, something that can enhance a firearm but is not itself the arm being kept or borne, and therefore does not automatically inherit the same constitutional status. Those are two fundamentally different ways of reading the word arms, and until one framework wins out nationally, defendants in different parts of the country are going to keep getting completely different answers to the exact same question, depending entirely on which side of a circuit boundary their case happens to land on. And it is not just suppressors. On top of all of this, the Supreme Court has already granted certiorari in two major Second Amendment cases dealing with so-called assault weapon bans, one out of Illinois and one out of Connecticut. Those cases are going to force the justices to directly address what counts as a protected arm under the Second Amendment when a government tries to ban a commonly owned firearm based on its features, like a pistol grip, a telescoping stock, or a forward grip. Arguments are expected this fall, with a decision likely sometime in the next term. Whatever framework the court lays out for analyzing hardware bans in those cases could end up shaping how lower courts, and maybe even the court itself, eventually analyze suppressor bans too. If the justices lean heavily on the common use and plain text arguments that gun rights groups are pushing in those cases, that same logic lines up very well with the argument that suppressors, which have been commercially available and lawfully owned by civilians since long before 1934, deserve the same treatment. So you have three separate threads all converging at once right now. You have the Fifth Circuit in Comeau openly inviting a challenge to Peterson. You have a hard circuit split between the Fifth and the Ninth on whether suppressors are protected arms at all. And you have the Supreme Court already gearing up to hear major arms cases this fall that could reshape the entire framework everyone is arguing under. Individually, any one of these would be a big story. Together, they suggest the legal ground under the NFA is shifting faster than it has in years, and honestly, faster than it has moved in decades. Now what happens next? Comeau's legal team is almost certainly going to push for further review, either asking the full Fifth Circuit to rehear the case en banc, or taking it straight toward the Supreme Court given the fresh circuit split with the Ninth Circuit. Given that two members of the very panel that just ruled against him are on record suggesting Peterson was wrongly decided, there is a real argument for the full court to step in and clean this up themselves before the Supreme Court has to, but there is no guarantee that happens quickly or at all. En banc review is discretionary, and the Supreme Court sets its own calendar with zero obligation to take any particular case just because a split exists. What I would watch for over the next few months is fourfold. First, watch whether Comeau's team files for rehearing and what language they use pointing directly at the concerns raised in this new concurrence. Second, watch whether de Bourbe's side, or the government in that case, seeks further review out of the Ninth Circuit, because a petition from either side of this split could become the vehicle that gets suppressors in front of the Supreme Court. Third, keep an eye on how the court's eventual ruling in the Illinois and Connecticut hardware ban cases gets written, because the reasoning the justices use there is going to ripple into every other arms case sitting in the pipeline behind it, suppressors included. And fourth, watch which judges actually end up sitting on any future en banc panel if the full Fifth Circuit agrees to rehear a suppressor case. Circuit courts do not always seat every judge on the full en banc panel, and depending on how that panel shakes out, you could see a very different result than what three judges alone produced in Comeau. A full court may made up of judges who are broadly skeptical of expansive gun regulation is going to look at Peterson very differently than a panel with a more mixed makeup. That is exactly why the concurrence in this new opinion matters so much. It is not just legal commentary, it is effectively a signal flare sent up by sitting federal judges telling their own colleagues and telling litigants everywhere that the door is open if someone wants to walk through it. For anyone actually in the process of legally acquiring a suppressor right now through the normal Form 4 transfer process or building one through an approved Form 1 application, none of this changes what you are required to do today. You still have to file the paperwork and wait for approval before you can legally possess it, regardless of which circuit you live in. It is worth noting that the $200 NFA transfer tax itself was eliminated starting January 1st of this year, which is a separate development from this litigation, but the underlying registration and background check requirement is still fully in effect everywhere, including in the Fifth Circuit. What this ruling changes is the legal record, not the paperwork. Every time a circuit court writes a decision that flatly states suppressors are constitutionally protected arms, that language becomes ammunition, so to speak, for the next lawyer trying to convince either the full circuit or the Supreme Court that the current registration scheme cannot survive much longer in its current form. Comeau adds another brick to that wall. It does not knock the wall down by itself, but it is one more crack running through the foundation of the NFA as a whole. I also want to be clear about something, because I know a lot of people are going to see the words unanimous ruling and suppressors or protected arms, and assume this means the NFA registration requirement itself just got struck down nationwide. It did not. This ruling is narrower than that headline might suggest at first glance, and understanding exactly how narrow it is matters if you are trying to have an informed conversation about this with anyone, whether that is a friend, a family member, or someone online who saw a different headline and got the wrong idea. The constitutional question got a clear answer. The practical registration requirement did not go anywhere, at least not yet, and not in this specific case. Comeau still lost. The law on the books has not moved yet. What has moved is the legal argument underneath it, and arguments that gain enough traction eventually turn into rulings that do change the law. Something else worth sitting with is just how fast this entire area of law is moving right now compared to even a year or two ago. For most of the time the NFA has existed, suppressor law barely changed at all. You had the same tax stamp process, the same waiting periods, the same basic framework, decade after decade, with almost no serious judicial movement. In the span of about a single month, you now have a DOJ reversal reflected in ongoing litigation, a Fifth Circuit panel flatly declaring suppressors are protected arms while still upholding a conviction, a Ninth Circuit panel going the opposite direction entirely, and the Supreme Court agreeing to hear major arms cases that will likely shape how every one of these disputes gets analyzed going forward. That is an unusual amount of movement packed into a very short window, and it tells you this issue has reached a tipping point that has been building for a long time. I think it is also fair to point out that this is exactly the kind of moment where it becomes easy for headlines to run ahead of what a ruling actually says. You're going to see a lot of framing out there calling this a total suppressor win, or claiming the NFA just got struck down, and neither of those things is accurate based on what the court actually held. The win is real, and it is significant, but it lives specifically in the constitutional holding itself, not in any change to what you are required to do on paperwork today. Understanding that distinction is what separates a useful breakdown of this ruling from a headline that oversells what happened, and I would rather give you the accurate version, even if it is a little less dramatic than the version floating around social media right now. Gun owners deserve the real picture, not just the version that gets the most clicks. So here's what I want to know from you. Do you think the full Fifth Circuit steps in and overturns Peterson before the Supreme Court ever has to touch this? Or do you think this drags all the way to the Supreme Court regardless, especially now that there is a clean circuit split sitting right there waiting to be picked up? And with the court already set to hear arguments this fall on the Illinois and Connecticut hardware ban cases, do you think that ruling ends up helping the suppressor argument, or do you think the justices keep those two issues separate? Let me know your take in the comments below, because I read every one of them. If you found this breakdown useful, do me a favor and hit like, drop a comment with your thoughts, and subscribe with notifications turned on so you do not miss the next update. Because between Comeau, de Borba, and the Supreme Court's upcoming arguments this fall, this story is going to keep moving fast. The cracks in the NFA are wider than they have been in years, and every ruling like this one is another step toward a final answer. If you have been following the Peterson litigation, the Comeau fight, or any of the other NFA challenges working through the courts right now, this is the moment to pay close attention, because the next few rulings could set the direction of this fight for a very long time. Thank you for watching, and I will see you in the next one.